Good afternoon, everybody, and thank you for joining our latest webinar. And today we will be covering the latest as much as possible on the EU settlement scheme, both in country applications and out of country. My name is Sarah Pinder and I'm a barrister at Goldsmith Chambers. I'm also the joint head of team of the Immigration and Public Law team there. I'm joined this afternoon by Bianca Valperga from Here for Good Immigration Caseworker, who is going to be helping us with Zambrano applications and joining family members. So welcome, Bianca, and thank you for joining us. And also Luke Piper, who is Head of Policy and Advocacy at the 3 Million. Those who have joined our webinars before on EU and Brexit areas of law will have seen the previous webinars that we've done with Luke. And Luke is kindly joining us today for the latest developments on extended family members. And he's had the hard task of coming to grips with very, very hot off the press guidance. So we're very grateful to you, Luke, this afternoon, and time permitting, Luke will also cover some latest developments on comprehensive sickness insurance, CSI. Sadly, we are not joined as of yet. There may be a small chance of Samina joining us a bit later in the webinar. So if you see her pop up, that's why. But otherwise, please accept our apologies. She's been delayed from a commitment this morning and so may not be joining us. And so I will take the position in terms of just starting off the webinar shortly with late applications under the EUSS and taking you through that guidance. As usual, in terms of these Zoom webinars, we've got facilities for a Q&A, time permitting at the end. Please, if I may ask you to put your questions in the Q&A box. I will try and keep an eye on the chat, but it may stretch my multitasking skills somewhat. And do forgive me if I don't see any questions there. And as you will have heard, the webinar is recorded and we will make the slides that you will see throughout this webinar, as well as the recording available as soon as possible, very likely tomorrow or Thursday, as soon as we can, and you will get notified of that via your email. So I will just continue on if you bear with me. As I mentioned, those are the areas that we're going to cover. So late applications first, then Zambrano, joining family members, extended family members, and CSI. I've just put in at the bottom of this slide, as you'll see, just again, the key dates. We should, I think, all be familiar with the key dates that we're dealing with, but it never harms, I think, to refresh those and to keep those in mind, particularly as you navigate Appendix EU in terms of Annex 1. You see references to specified date, required date, that sort of wording. And so usually it's one of these two dates. So you've got the withdrawal date in terms of the date that the UK formally left the EU on the 31st of January 2020, but then an important period that's followed and that's since ended, and that is the transition, or otherwise known as implementation period, so TP or IP for short, and that ran until the 31st of December 2020. There's this whole set of regulations that takes us beyond that in terms of retaining, saving, and specifying various parts of the previous EEA provisions and laws and regulations, and we've covered those in previous webinars, so we won't focus on those today in very much detail. But the other date that I wanted to flag for our purposes is the in-country applications under the EUSS, so under Appendix EU. Those lodged after Brexit, so after the 31st of January 2020, will attract a statutory right of appeal as well as an admin review. So prior to that, under the EUSS, you may recall, it was a question of just an admin review and then a judicial review if you had to resort to that. So just briefly looking at late applications. So in terms of in-country applications for EEA nationals to retain their residence rights in the UK, and for those family members, third country nationals, or similarly EEA nationals themselves, to retain rights of residence if they were resident in the UK prior to the 31st of December 2020. An application under the EUSS needed to be made, and that at first was until December, but was subsequently extended to the 30th of June 2021. So as this period continued, there were calls for extensions of a deadline, there were JRs about it, but effectively what's happened, as some of you will know, the exceptions or the mechanisms for a late application on reasonable grounds has been bedded in to the immigration rules themselves. So at first it was guidance, and then it was subsequently inserted in the rules. Where you go for that is effectively in the withdrawal agreement, and you will see here, if I just minimize my thumbnail, sorry, you will see here that it's in Article 18D, which is the most relevant. The withdrawal agreement itself, and it's important in my view to go back to the source, really, to the primary legal framework. The withdrawal agreement itself allows effectively indefinitely for applications to be made after the deadline that was set, and the deadline set was 6 months after the end of the implementation or transition period, so i.e. 30th of June of 2021. And I've recopied here Article 18D, which states that the competent authority shall assess all the circumstances and reasons for not respecting the deadline, and shall allow. So again, the wording here is important in terms of a duty, in terms of a must. It's not a discretionary if you can meet the various limbs of this paragraph. Shall allow those persons to submit an application within a reasonable period, further period, sorry, of time, if there are reasonable grounds for the failure to respect the deadline. Okay, so reasonable grounds is the term that you need to become familiar with if you're looking at helping someone with a late application. And for that, you can turn to the EU settlement scheme, EU, other EEA and Swiss citizens and their family member guidance. So that is Home Office guidance. The link here is live. It will also be live on the slides that you will receive after today. So you can go directly to it from the slides. And as I mentioned earlier, it's also been incorporated in terms of the term and the mechanisms for the reasonable grounds into the immigration rules. And so on this next slide, I've just highlighted, really paraphrased and summarized and extracted parts of that guidance. And I'll just bring a few things to your notice. And that is that here you have at the top a very important paragraph, I feel, that we can use over and over again because it has become necessary to use it. And that is in line with the general approach under the EUSS of looking to grant status rather than for reasons to refuse. You must take a flexible and pragmatic approach to considering, in light of the circumstances of each case, whether there are reasonable grounds, etc., etc. So really, this approach that you are looking to grant, you're not looking for reasons to refuse, you need to be flexible, you need to be pragmatic, needs to run through the whole scheme. And I'm afraid to say from experience already, and Luke and Bianca may be able to fill us in as well, it's certainly not been our experience across the board. Obviously, there've been a lot of grants and so forth, but there's been a fair amount of refusals and approaches that can't be described as flexible and pragmatic. The guidance, having said that, is very, I find very useful in the sense that it is fairly comprehensive. It covers a lot of different circumstances, a lot of different scenarios, quite wide-reaching as well. And I say that in the context of guidance of the Home Office, when there's discretion to exercise discretion in favour of someone who's overstayed, for example, that sort of guidance is usually quite limited in terms of the circumstances that it tries to cover. Whereas this, I feel, is slightly different. Children whose parents or local authority fail to apply on their behalf. So that's quite a big one in terms of a lack of awareness often that children themselves also need to apply, not just their parents. And then, you know, the usual set of vulnerabilities, difficulties in terms of domestic violence and so forth. There is quite a good catch-all here in terms of other compelling practical or compassionate reasons, including lack of awareness. So I think the Home Office has taken that on board in terms of a lack of awareness of the scheme generally and the obligations to apply before the 30th of June. Lack of internet access, limited computer literacy, again, that's been taken on board to a certain extent because of the nature of the scheme being digital as well. So do delve into that. If you need to advise clients, if you are helping someone, make a late application, because there is quite a lot to use that you can cite from in any representations. And this last slide, I think, on reasonable grounds and late applications is also just trying to highlight that there may be different circumstances. Obviously, the guidance can't, and it recognises that it's a non-exhaustive list of set of circumstances, but it can't cater for all situations. And what I want to highlight here in this bullet point is also that there will be reasons for a delay in an application that may actually be connected to a reason why you couldn't meet the eligibility requirements at that time. So, for example, durable partners or persons who had wished to marry last year, for example, and because of public health restrictions were not able to do that. And so they may have missed out from applying as a direct family member by the 30th of June. And there may be difficulties in fitting in placing that person within the durable partner category. So that is not something that's provided for in the guidance for perhaps obvious reasons, but maybe something to obviously just bear in mind, and it may be, I think, something to explore further as to whether there's any Article 8 arguments or, again, compatibility in terms of the withdrawal agreement and what is set out there. And because this sentence is so important in terms of the flexible and pragmatic approach, again, I've just repeated it there for you. So that's my piece on late applications, and I'm going to, forgive me for taking a bit of time, I'm going to just stop there at this stage. Sorry, I'm going to need to stop to share, and I'm going to hand over to Bianca, and I'm going to reshare my screen with her sets of slides. So just bear with me for that.
Thank you, Sarah. So maybe I can just start by introducing myself. I didn't need the slides for that. So hi, everyone. My name is Bianca Valperga. I'm an immigration caseworker for Here for Good, and I'm based at Southwest London Law Centre. The topics that I'll discuss in this webinar today are Zambrano, carers, and joining a family member. Now, both of them are extremely big topics, so we cannot essentially go through the details of them all in this 15 minutes presentation. So what I'll aim to do is to give a brief outlook on what Zambrano carers are and what joining family member are, and just highlight some recent developments or challenges or difficulties that we have been seeing. Of course, if there's space and time in the Q&A session, we can discuss more if there's something specifically that you want to discuss. Also, just an introduction of what Here for Good is. Here for Good is a charity that was set up to provide free immigration advice to EA national and their family member. We provide different essential venues through which we provide legal advice. So we have a phone and an email advice line, as well as we take on cases for one-to-one assistance. I can refer you, yes, that's the slide. Thank you, Sarah. If you need help, or if any of the clients need help in that sense, on our website, which is hereforgoodlaw.org, you can find the opening hours of our advice line and the referral pathway. We are taking on referral at the moment, so if anybody is interested in making that referral, they can look on our website and see what the pathway looks like. So if we go to the next slide, essentially is what I mentioned before, just what I'm gonna talk about, and I'm gonna start with Zambrano carers. So Zambrano carers were, well, first of all, the Zambrano care comes from our derivative rights of residence, and they come from a judgment that was before the CJU in 2011 of Zambrano. So that was the first time that the Zambrano principle with relation to EU law was defined, and that essentially everything started from that judgment. Zambrano carers were also considered within the EU settlement scheme from May 2019, so a bit after the opening of the scheme. And I've put in this slide the definition that at the moment is in Appendix EU of a Zambrano carer. So just quickly, essentially, Zambrano carer is a person satisfied the Secretary of State that they were residents for a continuous qualifying period in the UK with the derivative rights of residence by virtue of Regulation 16 of the EU regulation. EU Regulation 16 and Regulation 5, we will see in the next page. And then I've highlighted in red one of the requirements that currently is in the Appendix EU requirements, which is that the person is without leave to enter or remain in the UK unless granted under Appendix EU. We will come back to that just after a couple of slides. And that is essentially the main point of my presentation today. So the challenges and the developments regarding that point. So just in the next slide, I just put down also what the requirements are from Rule 16 of the EU regulation. So whenever you're looking at Zambrano care, you have to look at Appendix EU and of the EA regulation to essentially have the definition of what a Zambrano care is. And in the next slide will be just in terms, as I said, it's just a very quick definition of what Zambrano care are and what the requirements are for that. The first would be, well, I normally start actually with the British child. So just establishing British citizenship of the child and the fact that they were and they are residing in the UK. And then you have to move on to establish that the person is a primary carer. Also, just to highlight, the primary care doesn't mean that it's the sole primary carer. Primary care can be shared. So there can be an option of someone is applying as a sole primary carer, as well as someone that's sharing care responsibility with another person. And then point 4 essentially is the main point of any Zambrano application, and that is establishing that the child will be unable to remain in the UK or the EAA if the primary carer left the UK. Essentially, in very essence, that means establishing if there is another parent or another relative that can take care of the child, and if that person, and if those care arrangements will be suitable for the child. Always remember in this point, the best interest of the child has to be considered as a primary consideration, as should be with any application that concern children. So that should be considered in essentially balancing the situation of the child and decide if the child will be compelled to leave the UK if their primary care left the UK. Another thing to remember is that in order to be able to apply under the scheme, the applicant has to have been a Zambrano carer by 31st December 2020. And then they have to have completed a continuous qualifying period of time as a Zambrano carer, either of 5 years or less than 5 years, depending for what status they're applying for. And then just quickly, they have to have submitted a valid application, which in case of Zambrano carers is a paper application. And they have to have submitted that by the deadline applicable to them, which I'll quickly discuss afterwards. And they have to have satisfied the suitability consideration as with any other USS applicants. So specifically, what I would like to just analyze today is the last requirement, if you want to say so, as it stands right now with Appendix EU, which is that the Zambrano carer cannot have leave under another part of immigration rules, except Appendix EU. I put down there a link to the guidance. Again, as it stands right now, that's also what the guidance says. But as we will see in the next slide, there was a judgment in June 2021, that is the Akinsanya judgment, that specifically dealt with this last requirement. So the challenge was brought by Hackney Community Law Centre, and the claimant was Miss Akinsanya, who had 4 young children, one of which was a British citizen. She applied for Appendix FM leave, and then she later applied for Appendix EU leave as well, but she was refused. And mainly the point of refusal was that she already had leave under another part of the immigration rules. Now, what is really interesting about this judgment, and I've linked it in the slide as well, and if I may, I will suggest to anybody that is watching this webinar to have a look at the judgment. It is very interesting how the judge analyzes regulation, the year regulation, and the aim and the point of the Zambrano judgment. And essentially from this analysis, what the judge and the courts agrees is that the Secretary of State has actually misread herself in interpreting Regulation 16, because regulations only exempt those that have indefinite leave to remain from also having a Zambrano right. Essentially, that means that according to this judgment, the requirement that essentially excluded those that had limited leave to remain in the country to apply for a Zambrano right is unlawful. I think it's also very interesting how in the judgment, and that's why I suggest reading it, the judge acknowledges the situation in which people find themselves when they are on limited leave in the UK. So the situation of uncertainty that people have because they have continuously have to apply for further leave with high fees. So that's something that the judge acknowledges to essentially compare it and contrast it with the situation of someone that has indefinite leave to remain in the country. What happens after this judgment is essentially that the Home Office has to reconsider Appendix EU. Now, what also happened right after the judgment was handed down is that the claimant went back to the court, essentially to ask for an extension of time for a Zambrano application under the EU settlement scheme. And that's how the consent order of the 17th of June, 2021 was issued. And I've analyzed here the 3 main points essentially of the consent order, which is that as of now and until a reconsideration has been made, application as Zambrano under Appendix EU are essentially paused. They will not be determined. That should also mean that they are not determined in the negative, so that should also be not refused. The consent order also accepts and makes it possible that people can have 2 outstanding immigration applications at one time. So as long as they are based on the same reason, an applicant can have an extension of leave under Appendix FM, as well as a USS Zambrano application. And also the judgment and the consent order essentially allow for a period of time, which is not less than 6 weeks from the publication of the reconsideration from the Home Office, during which Zambrano application can be made, and they would fall within the reasonable ground that Sarah mentioned before in her slide. So just that is what at the moment is in terms of Zambrano application. In terms of when we will have a bit more clarity, it was announced that essentially, of course, Akinsanya was appealed, and the hearing of the Court of Appeal should be the 7th of December of this year. So hopefully that will mean that by then, around those days, we will have a bit more clarity of what will happen to Zambrano applicants and what will happen to the reconsideration. I also just wanted to make a quick point regarding deadlines for Zambrano carers. So first thing to mention is that if the Zambrano carer had leave, limited leave at the time of, essentially at the time of the deadline for the USS, which was the 30th of June, 2021, they also fall within that category that Sarah mentioned before. So they have reasonable grounds to make a late application, meaning after June 2021. Of course, the best option for someone that didn't have leave back then was to have made an in-time application. That way they would have protected their rights under the youth settlement scheme. And as I mentioned before, just to consider that there will be this 6 weeks, at least 6-week period after the consideration, during which also application under the EU settlement scheme as Zambrano will be considered as reasonable ground as to why they didn't meet the deadline. Just to close off on Zambrano carers, I just made a quick slide with a couple of points that I have with regard to Zambrano carers application and what kind of difficulties they might have. The first one is what I mentioned before. At the moment, we don't have necessarily clarity on how the Home Office, if the Home Office is going to reconsider Appendix EU. What we know so far is that applications should be paused and negative applications should not be reached on Zambrano application. So that is something to consider if someone needs to make a Zambrano application at the moment. What I put down as a second point is something that we have been considering when we are receiving Zambrano referrals, which is essentially the interplay between Zambrano application under the EU settlement scheme and their limited leave as they have under Appendix FM. Specifically, that will be the position that they will have once they granted USS status. So if they're granted settled status, they will have full access to anything, specifically to benefits. Whilst if they're granted pre-settled status, then they will be in a bit different situation because of the challenge is still ongoing with Fratilia. So essentially, what I would like to point out with that second point is that when someone is considering to make a USS Zambrano application, if, for example, they will be eligible for pre-settled status and they currently have access to public fund, that I think is something that the applicant should be made aware of and should make a reasoned decision on, just in terms of their access to benefits should they obtain pre-settled status. The other point that I just want to quickly make is that because of the uncertainty around Zambrano, we also strongly suggest our applicants to make at the same time an extension of their leave application, just so that if the Zambrano USS application is not successful, they would not have broken their continuity of residence for the 10 years road. So those were my points regarding Zambrano. Sorry if there were a lot in a short period of time. We will now move on to joining family members. Just as a distinction under the USS, we have to think of two different kinds of family member. First category is those that were resident in the UK before the 31st December 2020. And they should have submitted an in-time application by June 2021, or they can make a late application right now. The other type of family member is joining family member, and those are the one that joined their EA family member after 31st December 2020. And they also can apply if they satisfy certain requirements under the EU settlement scheme. So joining family member, just as admin point, that category was introduced back in October 2020. So that's a recent addition to our USS word. In terms of how an application can be made for joining family member, I just want to make a point of that because that's where we have some recent developments. So in our next slide, I just put down the difference between applying outside the UK and inside the UK. So an applicant will have possibility of doing both. Outside the UK, most times the applicant will need to apply first for a USS family permit, and that is essentially as a result of the rules surrounding application from outside the UK, which allow people to do that if there are either EA national or if there are non-EA national with a residence card. So working on the assumption that most people or a lot of people might not have, most non-EA national may not have a residence card. That's why I put down that they should first make a USS family permit. And then once they're inside the country, within 3 months of their arrival date, they should make an application under the EU settlement scheme. For application made inside the UK, that's where the changes come from. So it used to be that you couldn't apply inside the UK if you were in the UK as a visitor. That was changed recently, so that took effect on the 6th of October 2021. So from that moment on, people, even if they're a visitor in the UK, can apply under the EU settlement scheme. I recently made an application for joining family member, and unfortunately the form still shows that if you're a visitor, you cannot apply. Disregard that, that is not correct. Someone that is in the UK, even if there is a visitor, they can apply from the 6th of October 2021. So that's essentially the main change and the main development with regard to joining family member since their creation. Just a quick understanding of who can apply. Those are the category of people that can apply under the EU settlement scheme of the joining family member. The important thing to remember is that even though they joined and they reached the UK after January, their relationship has to exist before the end of December 2021, unless it's a child that is just born. And in that case, it's 3 months after birth of a child, an application will have to be made, and their sponsor will have to be a relevant EA citizen, which in essence means someone, EA national, that has started their residence before December and has obtained pre-settle and settle. The last requirement for joining family member is in my next 2 slides. Essentially, that requires a joining family member to either have never lived in the UK as a family member of an EA national, or to have done so, but have broken their continuity of residence either for a period of time spent outside the UK or for one of those conditions mentioned in the supervening event definition of Appendix EU. Again, I can talk more about this. There's specifically some issue with regard to durable partner, but I'm very conscious of the time. So I would just propose that that will be it for me for now, but I'm happy to take questions on that at the end of it.
Thank you, Bianca. A masterclass, if I may say, in covering a lot of materials very clearly and in a short space of time. So I stopped my screen sharing. Thank you for making yourself available for questions at the end as well. And we'll turn to Luke now, another masterclass provider in dealing with complex information. Again, as I mentioned earlier, very recently published concerning extended family members in the first instance. So I think, Luke, are you okay to share your screen for your slides?
Yeah, let's, host has disabled participation in screen sharing, so I think you have to give me consent, Sarah, to...
Apologies, everyone, we were rushing a bit at the start, so I will...
The wonders of Zoom.
Yeah.
There we are.
Yeah.
Okay, so... There we are. So hopefully everyone can see my screen now, which is good. So I'm going to talk through the issue for extended family members and a bit about comprehensive sickness insurance if I'm able to. But what I wanted to just do first of all is just post a link in the chat to a rights table that we've put together, which talks about summarizes some of the points that were just discussed there about joining family members and the issues at the border and things like that. And there's some information that we tried to have it as up to date as possible, but there are still some quite grey areas, but hopefully that will be helpful for people. But turning to the matter at hand, extended family members. So I'm sure there's a few of you on the call, on the Zoom today, who have clients who are in this area. We are talking about those other family members, so not the family members within the list that was just set out before, but those who are other family members and had to apply before the 31st of December to join their EU citizen family member here in the UK, and they were relying on the EEA regulations. Now, the problem is that, as I'm sure some of you are aware, is that a lot of these cases were refused and appealed. A lot of these people were successful, but they never received a permit. There's a long delay, and that largely is understood to be related to COVID. There are also issues of family permit right up until the end of June 2021 this year, where they were only given a few little days to be able to travel to the UK. And this is all because the documents that they were applying for essentially evaporated at the end of the grace period by the EU settlement scheme deadline of the 31st of June. And as such, there are lots of people who had legitimately and successfully applied to come to the UK as extended family members who were refused and waiting or whatever, and they had no means, no way of getting here because the government weren't issuing or didn't have a means by which to issue documents. So the estimates on this were that it was potentially hundreds, if not thousands of people who were impacted, and it was widely reported in the press, and most notably in The Independent by May Bullman. And what's essentially the question here is, why is it so important? Well, it's just all of these families are impacted, and it just poses some quite significant questions, but also it just strikes to the very core of the withdrawal agreement that the UK government had agreed to allow and facilitate these families to come to the UK. And it was the case that the government have now acknowledged that these people's rights are protected, but we're still to see anybody being issued any documents. It's still very much the case that lots of people are waiting. But yesterday, the government did publish a guidance document, sort of an amendment to a guidance document, I should say, which I'll paste the link for here. And within that, they have introduced the process by which they will now consider people to give these extended family members permits. I'm yet to know of anybody who's been given a permit to come here. I know of some people who've been given leave to remain with applications inside the UK, but I'm still unaware of anybody to be given permits. Now, there's a lot of judicial review that's been going on in respects of this for people who've appealed and haven't received decisions, for those who were issued last minute permits. And in a lot of these cases, they are going through the phases of getting consent orders agreed. And I've fortunate enough to be able to have sight of some of the text of these consent orders, which is giving us a very clear understanding of what the government's intention is in terms of these cases, that they are expecting people essentially to sort of reapply, but without putting in an application. So the government is retrospectively going to check these cases to make sure that they still meet the criteria, despite winning an appeal in most cases, if there've been any material change in circumstances, and that they don't fall to be refused on suitability ground. This is really problematic. It's a very problematic approach, not just because it creates lots of delay for people, but it does seem to contradict the government's own policy with respect to allowed appeals, which I'll post here. And it also appears to contradict the controversial decision of ULA, where the court essentially said that you can go back on a decision, but only if facts were sort of reasonably available at the point of the decision. So material change in circumstances most certainly would not have been available to a judge who'd been adjudicating the case at the time. So it does seem to be a lot of problems with this approach that's been adopted. We're still learning and still seeing what will happen. But I think what's really important is that those who are litigating judicial reviews at the moment, those who are dealing with consent orders, should very, very carefully consider the inconsistent approach that's being adopted, and make representations to that effect in any litigation. Obviously, it depends on the specific circumstances of any case, but my understanding is that in the majority, these do largely seem to relate to those that have appealed, have been successful in their appeal, and are pending a document. So given the terms, these seem to be the standard that's going around in terms of these. Something very, very carefully, but they may not necessarily have judicial review proceedings and have the fortune to be able to participate in that way. I think it's prudent to advise clients to think carefully about this guidance and think carefully about what information they need to provide in the event that the Home Office asks for this stuff. A side note here, it's quite startling how I don't quite see how the government is going to navigate this very efficiently, given that these cases are at so many different stages. Some of these cases were successful at appeal, and then they were told that they wouldn't be able to get a document, and they didn't do anything about it. So it's not clear how the Home Office is going to identify those people, to reach out to them. Likewise, those people whose documents expired right at the end of June and they didn't have time to come to the UK. Again, how are those people going to engage with the Home Office? What's the mechanic for that? It's not very clear in terms of the process. So I expect that there should be more confident. Most of these are the kind of questions that I'll be, we and others will be asking. But I think the key thing is to prepare clients for the possibility that they will be asked for further information. It is still quite vague. The guidance document refers to the prospect that the family member may have died. So they need to show that their EEA family member here in the UK isn't dead. How you prove a negative, who knows? But nevertheless, there you are. That seems to be the line of reasoning that they're going down. It's not certain that everybody is going to be asked to show that they still meet the requirements, but there is the possibility of it. So I think it's a question of arming your clients with the expectation of that, but also preparing them to have that information to hand over nice and promptly, so there isn't any more anxiety and delay with these cases. And finally, for those unfortunate people who come at the end of all of this unable to meet the criteria, I think people, particularly in these situations, need to look to the withdrawal agreement and Article 9A2, which is a route under the withdrawal agreement, which I'm not particularly aware that the Home Office is catering for, but the withdrawal agreement says, it seems to anticipate that those persons who are presence is required by the union citizen in order for them not to lose their union citizenship rights. The withdrawal agreement does seem to envision that there will be scope for those family members to be allowed to come and be able to stay in the UK. They do appear to fall within scope of the agreement. The extent to this requirement is untested, and I am not aware that the immigration rules cater for this, but it's definitely something worth considering, given where we seem to be with these particular cases. And it's just general observation anyway. We have 15 minutes. I'm happy to whiz through CSI if that's okay with you, Sarah. Good. So moving to something else now, the issue of comprehensive sickness insurance. You're probably wondering, why are we talking about this, given that it's not a requirement for people to apply under the settlement scheme? Well, it is still a requirement in other areas, most notably in those who wish to naturalise to become British citizens. The government have still, that is a criteria to have had CSI, but they do have a discretion to waive it. The parameters of that discretion are unclear and continue to be so, which I understand is continuing to be a reason why people are choosing not to apply to naturalise, because of the uncertainty associated with CSI. Equally, there are children born to parents who should have had CSI, so we're particularly thinking of people born after April 2006, I believe, who have had their parents may have been studying, and when their child was born, they didn't necessarily have a permanent right to reside. And furthermore, there are those who have successfully naturalised despite not having CSI. They would face problems in exercising their right to family reunion, because they would need to show that they were exercising treaty rights at the point that they naturalised and thereafter, which is in direct contrast with those who don't naturalise, who don't need to show that they were exercising treaty rights to benefit from family reunion. So there are those areas. There's also the area that in deportation cases, the threshold of protection is ultimately higher for those who have been lawfully resident in the UK for 5 or 10 years. If those persons don't have CSI, then the threshold is lowered according to that. Now, if the CSI requirement were to go away, then the protections would then be a lot greater in those cases. And I suspect that's one of the reasons why the government is very resistant to changing the comprehensive sickness insurance principle. However, the European Court of Justice has sort of been asked this question in the case that's referenced C247/20, which is a case from Northern Ireland. It was referenced just before the end of December. The Advocate General has an opinion on the case, and there is a last remark which reflects on comprehensive sickness insurance, despite the fact that the question was not asked. But the Advocate General clearly recognises that this is such an important issue, not just within the context of the case, but also within the context of the conversation about what is comprehensive sickness insurance. And you will see that his analysis, drawing on some excellent academic work, but also on other jurisprudence, comes to the point where he says that those countries that, like the UK, where national insurance, national health care is provided to everybody free of charge, that should be essentially equivalence, and he does recognise that. However, we don't know how that will fit within the judgment that's due to come from the European Court of Justice. We don't know when that will be. The fact that it's a last remark and it doesn't necessarily fit neatly within the questions, I think could be problematic. It has a sort of obiter feel about it, if such a thing can ever exist within the European Court of Justice. I don't know. And so we shall see. But I think the legacy of comprehensive sickness insurance is not going to go away anytime quickly. As such, there have been some amendments that were introduced to the Nationality and Borders Bill, which seek to remedy this thing and fix it. Labour Party, the front bench, this is now Labour Party front bench policy, that they want to get rid of CSI in terms of those assessments. So there's a new clause that's been introduced. It's unlikely to succeed in the parliamentary theatre, but nevertheless, it shows you that this is still a live issue in the context of nationality law. And finally, just a brief nod to another interesting case that's going on at the moment, which has been granted permission to the High Court for judicial review, which is a case brought by the PRCBC, which they do some excellent work in this area, and they're hoping to address the Caporelli conundrum for those born between 2000 and 2006. I've put the post there for the updates within the chat. I won't go any more into detail on that, but it's just a point of interest more than anything. So with that said, that's the end of my presentation, and we can now move to questions.
Thank you, Luke. Yes, so important decision in the last bit as well. I think you nodded to it, but do look into it because it does affect nationality rights, and there may be some holding off to do for those that may otherwise be looking to sort out their British nationality. So in terms of Q&A, we have, let me just click all of them, and we've got 6 so far, and then our persons attending should be able to see those as well. But we have from Fatima for the Zambrano application, so perhaps for you, Bianca, if you're able to, would the period from the child's birth count towards the continuous lawful residence of 5 years for settled status? You're on mute, Bianca.
Sorry. Okay, so short answer, yes. For long answer, it's a bit longer. So essentially, someone becomes a Zambrano carer when all the requirements are met. One of the requirements is having a British child. So yes, from the moment the child is British, that's when you can start considering, is that person a Zambrano carer? And that's why I answered yes. But the long answer is, you still have to make sure that all the other requirements are satisfied. For example, from the moment of birth, was this applicant the primary care of the child, and would be the child unable to remain in the UK if the applicant were to leave the UK? That's all has to be considered to make sure that someone qualifies for Zambrano care.
Okay, thank you, Bianca. And another one from Fatima on, not on Zambrano, but on joining family members, so still with you, Bianca. Joining family member, can the JFM be a grandparent of an EU national child under 18 years old? So it's a bit of a quasi.
So my understanding will be yes. So they should go under the category of dependent parent, but then grandparents and grandparents are also within that category.
Descending
line. They will have to be
parents,
dependent,
right? And then descending. Yep.
Yeah. They will have to be dependent. So again, yes, the relationship will be the fact that they're the grandparents, but also they will have to be dependent on the EA national. And if we're thinking that the application most probably would be done after 1st of July 2021, as we are in October, November, you will have to prove dependency. So you will have to prove how is the grandparent dependent on the child, on the EA national. So you have to provide evidence of that.
Thank you. And that's a very good point in terms of highlighting the dependency and the need to evidence that. Because I can just share very briefly, a colleague of ours in Chambers, Charlotte Bayati, has a case that was granted, that has had permission to apply for judicial review, and the High Court granted, and shows the different approaches again between the EEA regulations 2016 and how dependency was either understood or didn't necessarily need to be evidence, and then how that's then shifted in some cases under Appendix EU. So her case, just very briefly, if I recall correctly, is a child who had a residence card as a child of an EA national, had been granted that either prior to the age of 20, it must have been prior to her turning 21. But then obviously once the EUSS came in, she applied for her pre-settled status and was required to show her dependency as she was then over 21 as well. And for various reasons wasn't necessarily able to do that. And so it just shows again the sort of, not necessarily inconsistencies, but different definitions. So watch out for that, as I think we've yet to see more instances of that panning out. So on to the Q&As. From Vicente Santos, can a durable partner of a relevant EEA national apply in country after 6 of June 2021, holding a valid visitor visa? So durable partners equals frazzled in terms of all of the different definitions and the provisos and the conditional criteria. The scheme was open to durable partners in country until the 30th of June. Am I right in summarizing that very?
I think that's fair. My general view with durable partners is I don't think you can ever answer general questions about it because of the construction of Appendix EU, and you have to walk a case individually through each of the hurdles. I just genuinely don't think that there is scope. I mean, you can, obviously there are the general principles of the withdrawal agreement, which you can sort of rely on, but in terms of walking it through Appendix EU,
yeah, I mean, Yeah, no, and I think that's right. In terms of Vicente's, the premise, I mean, the visitors restriction has obviously, as you heard Bianca, the visitors restriction has been recently lifted in terms of the joining family category. But as Bianca also highlighted, the joining family category is not open to all categories of family members. The crux in terms of how I see it, the problems with durable partners is that if you haven't had your durable partnership previously recognized as such under the regulations, then you encounter difficulties. So that's sort of my starting point. If a person hasn't made an application under the regulations, whether abroad or in country, pre-31st of December 2020 as a durable partner, it's a red light. And then you follow Luke's approach and you unravel and you unpick and you study the definitions very carefully. I think that's as far as we can take that one. One for you, Fatima, if it's the same, Fatima is keeping us very busy. How wide is the discretion to waive the CSI requirement in naturalization applications? So slightly tangential, obviously you mentioned naturalization applications, but that can be a webinar in itself in terms of the good character. Any views?
I think within the context of the guidance, the discretion is, well, it's that I'm to read from the guidance. It says some applicants who will have previously had an application for a document, you must assess the reasons given for this and why they did not then obtain it, yada, 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 and consider whether there are compelling grounds to exercise discretion. And I think that's the peppering that you see through the naturalization guidance is compelling grounds to exercise discretion where somebody didn't have comprehensive sickness insurance. There were previous, incarnations of the guidance where they did seem to be a little clearer on what that might look like in terms of people just not being aware. But there were some changes back in July where they did seem to sort of narrow. So it is unfortunately a vague proposition, and as such, it's very hard for an applicant who's going to spend several thousands of pounds on a naturalization application to run that risk. That's it from our experience. That's been the case. Loads of people just saying, I appreciate that. I may be fine, but I don't want to run the risk. I don't want to lose my money. And I think lawyers are put in a really difficult position because they're having to say,
yeah.
And
the difficulty also taking it forward is that if you are refused, then it's also because it's such a wide discretionary in the court area, and the courts have been clear in terms of other good character requirements and the discretion that effectively a prerogative that the Home Secretary has to grant you citizenship, that when you have such a wide area, the guidance doesn't help you too much. The courts are very cautious about sort of interfering further. In terms of further questions, we have one from Asan. A dependent parent who herself is an EEA national but has never lived in the UK or who remains outside of the UK, the best approach would be to apply for an EUSS family permit. Sponsors her daughter who's been granted British citizenship already but continues to hold the EEA nationality. Assume 30th of June deadline should have no impact on such an application. Any comments?
So the fact that the sponsor is a daughter who's British and a EEA national, essentially that will go within what they call in the Appendix U as a relevant naturalized British citizen, which in theory can be a sponsor for a joining family member. I do believe it's another situation where it's a bit of a can of worms, even as a durable partner, and for me it's a bit hard to discuss on a webinar. I believe also that should carry a paper application. That should be a paper application, so I'm a bit confused how for that USS. So I don't think that could happen from outside the UK. So that's probably why a family permit may be the best option. But it's a very complex route for naturalized British citizen. So I don't think I will be able to actually answer that fully on this
Yeah, no,
now. But if the person needs more advice, they can always phone the advice line if forget, and maybe someone can give a better answer.
And Asan, as with others, we'll have all of our contact details on the slides that will be made available. But that seems right in terms of, it comes from Lunes, the CJU decision in terms of naturalized. So if a person has never exercised free movement rights as an EA national, then there's a problem. But if the person exercised free movement rights and as a result of that they're naturalized, then it doesn't necessarily close the door, but can be complex, as Bianca said, and also wrongly dealt with by the decision maker often. So it's worth looking at that carefully. Una Boyd was wondering whether anyone has encountered an issue entering on a visitor visa if they intend to apply for an EUSS when in the UK on that visa. Can that be viewed as contradictory statements? Yeah, I was wondering that in terms of advising persons as well. If obviously it's a tricky situation, but if a person is not necessarily sure whether they want to make an application once they're here, then there may be a tricky scenario there in terms of them trying to come as a visitor first. Have you guys had any feedback so far since?
Lots of questions about it, and a lot of anxiety amongst those looking to travel, but also those advising people. And I don't necessarily think a very clear answer is being given by the Home Office. I think the reality is that there are so many things that people have to juggle with those sort of situations, but I think it's always right to err on the side of caution when advising people in those situations, but that if they are genuinely thinking about traveling to the UK as a visitor, but with the intention of then applying to stay as a family member, you can sort of see how that could go down if you were then found to have practiced deception at the border. Yeah. So you can see the nightmare scenarios that sort of are entangled with this. Plus, but I mean, I take the view that the purpose of the settlement scheme is to recognise your rights as family members. Family members coming to the UK can be visitors. The whole purpose of the family permit regime was essentially to allow family members to come in and visit with their family members. It was never there. It's not as though they have to have an intention to settle to be eligible for rights under the withdrawal agreement. So I do think that there is some flexibility within this, and I think that's potentially why there's some anxiety around with the Home Office and so forth. But I think at a practitioner level, it's always best to be cautious. But I appreciate. I mean, I know Una is in Northern Ireland, and I think that probably presents different complexities with the land border. So, but yes, it's. I've yet to hear anybody who's substantively had any problems.
Yeah, no, and I think that's right, and goes back to the flexible and pragmatic approach that I certainly went on about in terms of the context of reasonable grounds. And it's good to go back to that and really hold that to task. And same with the withdrawal agreement, just to keep on going back to that, because we can get lost in how all of this has been drafted and regulated or over-regulated and so forth. So thank you. I think we're reaching time, so we're going to have to stop there. I can't impose on Bianca's and Luke's time any further, I'm afraid. So thank you, everyone. And I think there are questions there that we haven't been able to get to, but we will try and do that in written form as best as possible with the email that will follow. Can I thank you again, Bianca and Luke? Have you got any closing remarks, your top tip for anybody that we may not have covered?
I don't think so. I think I talked enough, but thank you very much for inviting me to this panel.
Thank you.
I'd say one thing, and that's the thing I've said to everybody, which is if the Home Office is trying to encourage people inside the UK to withdraw their applications to the settlement scheme, please don't do it unless you're absolutely sure that that's the right thing to do, because the damage that could potentially cause to somebody families' continuity and their ability to live in the UK is, yes, it's really, really important. Like I've heard so many instances where people have been told to reapply, withdraw, not appeal, and things like that, and it's really not so straightforward, and you have to really, really be careful about it. So yeah, I just noticed there was a few little comments in the chat which sort of indicated thinking along that way.
Okay, thank you, Luke. No, that's certainly useful. And there are many resources that you can tap into, previous webinars, Here for Good, many organizations, 3 million, 2 of them that we've got today in terms of doing incredible work. And a final plug for them, we are trying to raise donations on behalf of both organizations. So if you felt this webinar was useful and you haven't donated, and if you are able to donate, please just spend the time on visiting the links that you will have accessed through the emails through Eventbrite, because certainly that work needs to continue. There's still a lot to cover, a lot to do, and many more conundrums, I think, that we haven't even begun to think about yet. So on that note, thank you both again, and we'll see you soon. Thank you.
Thank you.
Thank you.